Contract law supersedes statute. Why private agreements reign supreme in court. Most people think statutes rule the courtroom, but in truth, contract law reigns supreme. If two parties agree privately, even legislation often takes a back seat. Let's explore why private agreements override public law and how to use that power. Under both federal constitutional principles and commercial statutory frameworks, it is well settled that contract law operates with supremacy over conflicting statutes, provided that the contract is lawful and not in violation of public policy. This is not merely academic. It is a binding legal doctrine embedded within Article 1, Section 10, Clause 1 of the United States Constitution, which prohibits any state from passing a law that impairs the obligation of contracts. The legal implications of this are monumental. When two or more parties enter into a private agreement, that contract becomes enforceable as the highest form of law between those parties, above statutes, above state codes, and even above administrative rulings. Unless fraud, duress, or illegality can be proven, the terms of a private agreement will govern the relationship, regardless of conflicting legislation. This is the doctrine of freedom of contract, codified through decisions such as United States Trust Company v. New Jersey for 31 U.S. 1, 1977, which reaffirmed that even public entities are bound by the contractual obligations they voluntarily assume. Additionally, courts recognize that statutory rights can be waived by agreement. For instance, UCC Section 1-302A affirms that the effective provisions of this title may be varied by agreement, so long as the agreement does not violate good faith or manifestly unreasonable terms. UCC Section 3-104 and Section 3-311 reinforce that a negotiable instrument carries its own independent contractual obligation, which can override typical debt assumptions. Practically, this means that you may, by contract, redefine what constitutes lawful payment, limit liability through without recourse language, reassign debtor and creditor roles, and preemptively resolve disputes through binding terms and conditions. In litigation, judges are obligated to defer to the terms of the private contract before applying public statute. This is why attorneys often attempt to dismiss private contracts as unenforceable or commercial nonsense, because if the contract is admitted into evidence and properly defended, it nullifies their statutory arguments. Moreover, in the realm of secured transactions, the contract, security agreement, determines the creditor's rights in collateral, not the public statute. Even bankruptcy courts must respect private lien agreements if properly perfected under UCC Article 9. This understanding transforms the courtroom. Rather than arguing law, you are now enforcing contract, and judges become referees of the party's will, not arbiters of state policy. In this framework, your power comes from knowing how to draft, present, and assert private agreements that redefine the roles of all participants, up to and including government actors. Footnote: this section explains why, under the Constitution and Uniform Commercial Code, private contracts, when lawfully formed, take precedence over conflicting statutes in litigation.